Good morning, everyone, and thank you for joining us to hear from Judge Persky. I am Ladaris Cordell. I'm a retired Superior Court judge from Santa Clara County and one of the spokespersons of the No Recall of Judge Persky campaign. There are two campaigns against the recall. One is the campaign sponsored by Judge Persky, Voices Against the Recall. The other is a campaign formed by a group of women with extensive backgrounds in criminal law, criminal procedure, constitutional law, social activism, civil rights, social justice, and criminal justice reform. We formed our campaign to oppose the recall and to aggressively speak out on matters on which the judge cannot. Our campaign is No Recall of Judge Persky, and our website is www.norecall2018.org. This is Judge Persky's opportunity to speak to you and for you to ask him questions. Those questions that he cannot answer because of the rules that limit what sitting judges can say, you can direct to members of our No Recall campaign at the conclusion of this press conference. We have provided to you handouts from our website that spell out in detail the falsehoods that are being perpetuated about Judge Persky and his time on the bench by the recall campaign. The recall campaign, one that has had nearly 2 years to spin its false narrative without any opposition until now, has been stunning in its dishonesty. The spokespersons of the recall, while they have no background or experience in criminal law or criminal procedure, know better. They know that this recall is a threat to judicial independence and that their vindictive attempt to recall Judge Persky is pulling us back into the world of mandatory minimum prison sentences that resulted in mass incarceration of the poor and people of color. They also know that this recall has nothing whatsoever to do with the Me Too movement, but that has not stopped them from co-opting it. The recall has raised more than $1 million to spend on one judge who made one lawful decision. We urge the voters of this county to get the facts and vote no on the recall of Judge Persky. I now have the honor of introducing Judge Aaron Persky, a fair, honest, and respected judge who has served with integrity on the Santa Clara County Superior Court for 14 years and who we believe will continue to serve for many years to come. Thank you.
Thank you, Judge Cordell. Every day in every county in this state, individuals walk into courtrooms and they see up on the bench a person in a black robe. They are seeking justice. To those people, to those litigants, whether they be parents in a contentious divorce case, whether they be criminal defendants seeking a fair trial, whether they be victims in a criminal case seeking accountability and closure, we make them a promise. We promise as judges to rule based on the facts and the law and not on public opinion. In fact, we make jurors swear to that exact promise. One of the first instructions we give jurors in either a civil or criminal jury trial is, do not let public opinion influence your decision. When public opinion influences a juror's decision or a judge's decision, it corrupts the rule of law. This recall, if successful, will make it harder for judges to keep that promise. I want to talk about two first historical examples. Brown versus Board of Education, 1954, a U.S. Supreme Court case. Overruling Plessy versus Ferguson. Separate is not equal. It became the law of the land, and federal courts were charged with the task of desegregating public schools. School children in segregated schools had the right to demand that those federal judges enforce the rule of law. And they did so, and they did so courageously. Brown versus Board of Education was unpopular in many states and in many school districts, and it took years of litigation to vindicate the rights of those school children. Imagine for a moment if those federal judges had been subject to judicial recall in the face of that unpopularity. Fast forward to 2000. Here in California, the voters passed Proposition 22 by a vote of 61% to 39%. Proposition 22 made it the law of the state of California that marriage is defined as between a man and a woman. In other words, only marriage between a man and a woman is valid in California. It took 8 years for the Supreme Court of California to find that unconstitutional. It took 8 years for the judges of our state to vindicate the rights of same-sex couples. We ask judges to follow the rule of law and not the rule of public opinion. We may forget that in 2004, a Sacramento Superior Court judge named Lauren McMaster made a decision upholding the validity of the domestic partnership laws in California. Those laws gave same-sex couples certain rights. They could not marry, but the California legislature gave them certain rights akin to marriage. Lauren McMaster made a ruling upholding the validity of those laws, and he was subject to a recall effort. At the time, then Attorney General Bill Lockyer issued a statement, and I just want to read it for you. It's still on Attorney General Javier Becerra's website. Bill Lockyer said, in response to that recall effort, "Our system of government cannot function the way our nation's founders intended if the courts are reduced to being political weather vanes. When a group threatens to recall one judge because they disagree with a ruling, they threaten all judges. They threaten the independence of the judiciary. They should be opposed and they should be defeated." That statement is as true today as it was then, despite the different political forces at work. So where do recall proponents go when faced with this fundamental objection to the recall? They pivot. They say, Judge Persky is biased. 3 independent organizations have examined the claims of bias. The Commission on Judicial Performance, the Associated Press examined my rulings in jury trials in Palo Alto, and the Santa Clara County Bar Association. 3 organizations have rejected those claims. And yet, there is a consistent narrative about me, a caricature of me that has been allowed to flourish. And I want to give you some facts that counter that narrative, some facts about me. I was born in Berkeley in 1962. I was raised in San Francisco by liberal, permissive 1960s parents. I went to Stanford as an undergrad. I got a master's degree. I spent a total of 5 years there. And a few days after graduating in 1985, I got on my bicycle and rode to Washington, D.C. to raise money for the Red Cross African Famine Relief Campaign. In fact, it was the Palo Alto chapter of the American Red Cross that sponsored our ride. When I got to Washington, I looked for a job. My first job was as a bike messenger. And I looked for a job, and I did get a job at the U.S. Department of Commerce for the International Trade Administration and worked for the federal government. I returned to California to attend law school at UC Berkeley. And after law school, I joined the law firm of Morrison Forster. And I was attracted to that law firm because they had a reputation, a progressive reputation, They rewarded pro bono work by their associates. They credited pro bono work to the billable hour requirements of their associates. And when I joined Morrison & Foerster, they let me do pro bono work. Ultimately, I received an award or certificate from the State Bar, the Wiley Manual Award, for crossing a certain threshold of pro bono hours. I rode in the California AIDS ride 4 times. That ride from San Francisco to Los Angeles raised money for AIDS treatment and prevention. I joined the district attorney's office here in Santa Clara County. While there, I prosecuted sexually violent predators. I served on the Santa Clara County Network for a Hate-Free Community. I served on the board of the Support Network for Battered Women. I was appointed by Gray Davis in 2003 to the Santa Clara County bench, and I've served in the civil, criminal, probate, and family divisions of the court. I'd like you to compare those facts to the caricature of me that has reigned for the last almost 2 years. So why have I remained silent until recently? Well, I think judges typically should accept criticism of their decisions. It's legitimate. It's an absolutely justified avenue of public discourse. We should sit, we should listen, we should take it. We should take criticism from social media, take criticism from cable news, take criticism from print journalism. But the recall takes it one step too far. The recall, if successful, threatens the integrity of our justice system, and it demands a response. I know firsthand what it's like to be the subject of criticism, outrage, and negative attention. I know firsthand the pressures that can be brought to bear on judges for making decisions according to the rule of law and not the rule of public opinion. How many judges want to drive down the streets of their neighborhood with their 2 children in the car and see a lawn sign, their father's picture, next to a mugshot? How many judges want to come home one day and find this political mailer addressed to their wife? And this mailer accuses the judge of failing to protect his community. This is the political playbook for those who want to oust judges, whether it be at the trial court on a recall or whether it be a state Supreme Court justice. It's the politics of fear. It's to appeal to the public's fear of crime. It's to appeal to the public's sense of outrage over certain decisions that may not have been accurately portrayed in the media. What judge wants to sit in chambers contemplating a difficult, high-profile decision and know that somewhere out there, if someone on one side or the other is displeased with that decision, that that person is willing to contribute $221,000, a single individual, $221,000 to help recall that judge? This is the reality of judicial recall. This is my reality. I don't anticipate, if the recall is successful, there to be a spate of judicial recalls. It's much more subtle, and I believe much more insidious than that. The judicial recall, if successful, will be a silent force, a silent corrupting force, a force that will enter the minds of judges as they contemplate difficult decisions, a force that will enter the minds of individual litigants when they step into the courtroom, wondering, can that judge withstand the challenge? It's a silent force that will enter the minds of the public. One of our jobs as judges is to promote public confidence in the judiciary. And so you have to wonder if the recall is successful. Will the public wonder, will judges have the guts to make the hard decisions? I trust that my colleagues have the guts. I trust that they will obey their ethical mandate. I trust that they will put a laser focus on the facts and the law in every single case that comes before them. But I question, if the recall is successful, whether the public will believe that, whether they will believe that a given judge is willing to risk his reputation, her job, her career over a difficult decision. We should give judges the courage to make those hard decisions. Again, back to the promise. A litigant enters the courtroom. A father or mother in a child custody case, a criminal defendant accused of a crime seeking a fair trial, a victim in a criminal case seeking accountability and perhaps closure. We make a promise to them. We need to keep that promise. I think a successful recall will make it harder for us to do that. Thank you for listening. I'll take questions.
So, Judge? So I'll call on people, we'll ask people to ask one question and then give other people a chance before we come back to a second one. Yes, please?
Just Martin, knowing what went on this last 2 years, if you have to impose sentence again, let's say that, go back, would you do the same sentence or would you change the time that you gave Brock Turner?
The case is pending. As a judge, what I do all day is tell people to follow the rules. And the canons of judicial ethics require judges to stay completely mum on any pending case, and that includes a case on appeal. The Brock Turner case is on appeal. So I cannot answer that question. I'm not going to break the rules, the ethical rules that I'm bound by.
Yeah. Teresa?
If you do happen to lose, what do you plan to do? Have you thought of like a contingency plan?
That's a great question. I've thought about several things. I don't know. I haven't made any decisions. I'm focused on this effort. I'm going to put everything I can into this effort, and we'll see what happens on June 5th. Really what I'm asking voters to do is stop and think about the issue, about the implications of the recall.
Judge?
Oh, sorry, go ahead.
Yeah. Can you give us your impressions of the victim's statement during the case that came out that really went widespread and influenced a lot of people?
Again, because the case is still pending, I can't comment on the case. I think that would be a comment on the case. What I can say, though, and what the ethics rules allow me to do, is to point to the transcript of the sentencing. The transcript of the Brock Turner sentencing is now online. If you Google Brock Turner sentencing transcript, you will see it. My comments at the sentencing. And so I just direct you to that for what I actually said at the time.
If that's on the record, could you repeat what's on the record?
Because it's been 2 years, I don't think I can do that faithfully. So I'd rather just rely. And seriously, you can Google it in 5 seconds. You'll be reading it.
Bob?
California voters have had the constitutional right to recall public officials, including judges, since 1911. What do you think the recall should rightly be used for? Should it only be for corruption in office, proven dishonesty, or is it legitimate to, let's say, recall a judge for one or maybe a pattern of decisions that people don't approve of?
I think judicial recalls should be reserved for misconduct by a judge or incompetence. And there are 2 avenues to address that short of recall. There's, of course, appeal. We have, I believe in California, a very robust appellate process. We have a disciplinary system. The Commission on Judicial Performance investigates complaints against judges. So if those institutions fail, perhaps there's a place for judicial recall. If those institutions are not in fact robust, either on the appellate level or on the disciplinary level, maybe there's a place for judicial recall. But I don't think there's a place for judicial recall based on decisions, lawful decisions made by a given judge.
Yeah.
The recall campaign has accused you of having a pattern of bias. So given that, what would you like the public to know, and how would you like to respond to that?
I would like the public to know that I give due weight, respect, and consideration to every person that walks into the courtroom, regardless of race, gender, ethnicity. That's what we have to do. I take the rules of ethics very seriously. When confronted with an accusation or a pattern of bias, I would ask people to look at the sample size, to wonder if cherry picking has been involved, if there is certain confirmation bias involved in advocates who have selected certain cases out of the many cases that I've decided. And I would invite journalists to go to the source documents. Go to the source documents. Go to 270 Grant Avenue. Pull the files, read them front to back, make a list of the people who are involved in the case, call them, see if they'll comment. If they won't comment, talk to third parties. Find experts who can opine. We have advocates spinning facts that are contained in source documents, facts that are contained in court transcripts. Call up the court reporter, request the transcript. You can make your own determination. I will stand by a neutral determination. I stand by my decisions. Court documents are public records. Even though I can't speak about the cases since they're pending, I urge you to just take a look.
Judge, are you at all, let me ask it a different way. What was your reaction first when this all kind of blew up, and as it has continued over the past many months? What is your emotional reaction?
I would say initially disappointment. I would say it's just not, it doesn't feel good to be on the receiving end of so much negative attention. I remember a few days after the sentencing, I was sitting in my chambers and I got an email, and our court email addresses are sort of presumptively private. You can probably figure them out, as many members of the public have. And I'm sitting in my chambers and I get an email. It said, "Dear Judge Persky, how does it feel to be the most hated man in America?" And then it said something that I can't repeat publicly. So when you get that, there's a visceral reaction. And that negative attention influenced my family as well. It's influenced my job. It has permeated my life for the last 2 years. But again, I'm at peace with public criticism up to a point of recall because of the collateral damage that I think this recall, if successful, will do to our criminal justice system.
Judge Persky.
Is anyone else? Yeah.
You mentioned the sense of, appeal to a sense of outrage by the recall campaign. To the extent that that outrage is legitimate, could you speak to that outrage?
Sure. I think that the underlying passion of recall proponents is absolutely genuine. I think women are frustrated by how they're treated in society, how they're treated by the criminal justice system. We know that sexual assault is underreported, and so that passion is genuine. It needs to be expressed. One positive aspect of this whole recall is that it's become a larger public conversation about what do we do about it. And I think that's positive. I think, though, that when people are exposed to limited information, let's call it the Twitter version. I don't do Twitter, so I think they expanded the number of characters they're allowed to use. But if you give people a Twitter version of a case in a certain way, that can spark outrage. And I would simply say that let's use that passion not for judicial recall, let's use it for a constructive, productive purpose.
So this raises the question of whether the office of a judge should be an elected office. In some ways it relates to public opinion.
And so is your question?
Well, my question is, what is your opinion on that?
I think California has a good system of selecting judges. The vast majority of judges, Superior Court judges in California, are appointed by the governor in the first instance. There are so-called open seat contested elections when judges retire at a certain time in the election cycle. There are rarely contested judges where a sitting judge will face a challenge. So we have a hybrid system. Most are by appointment, and when a judge is appointed by the governor, that judge goes through a fairly thorough vetting process. And ultimately, the governor makes a decision whether or not to appoint. Again, that's, I think, I'm going to say, well over 90% of Superior Court judges in California get to be a judge in the first instance that way. Then we are subject to re-election, and there are contested open seat elections. So that's a safety valve. If the gubernatorial appointment process becomes overtly political or ends up with judges who aren't doing their job, there's a little bit of a safety valve. So I think California has a good system for judicial appointment. I think there's a place for judicial elections. But when, and one other, I think, important distinction between a recall and a classic judicial election is that if two judicial candidates are running against each other, they're subject to very strict ethical rules about misrepresentation, about conduct in the campaign process. And in a recall proponent is not subject to those ethical restrictions. And so when a campaign starts to resemble the politics of fear, that to me is when it crosses the line. I mean, is that the sort of democracy that we want with that type of politics? Do we want that politics to enter the courtroom in a way that, again, makes it harder for judges to keep their promise to put public opinion to the side?
There was a question in the back.
Judge Persky, in your opinion, you mentioned earlier Brown versus Board of Education and also the McAllister decision on gay-sex marriages. How is the Brock Turner case different in terms of an activist decision following or tracking or reflecting the changing value system of our society? When people are, as you mentioned earlier, very passionate today, many people are passionate about the issue of sexual assault and fair and just sentences.
Well, again, I can't speak directly to the Turner case. I think my point was that you don't know which side of the political divide you're going to be on when you want to recall a judge. If you're on the right side that the public supports, you may be happy with the notion of recall. But the political winds shift. And so I think the recall poses a challenge to, again, that promise that we make, which we have to keep: disregard public opinion. Public opinion just doesn't have a place in the courtroom. It doesn't, and I go back to that jury instruction. If jurors are influenced by what they perceive to be their notion of what the public wants them to do, they have strayed. They have strayed from the laser focus they must put on the facts and the law. In every jury trial, and if any of you have served on a jury, you probably heard the judge say this every time you leave the courtroom: don't talk to anybody about the case. Don't read any media reports about the case. And why do we do that? We want to insulate jurors from public opinion. We want decisions to be made based on what happens in the courtroom. Now, appellate courts can make grand decisions about public policy or society. Trial court judges are charged with a pretty narrow mandate, which is you have a litigant on one side and a litigant on the other side, and you close it off to their case. You tune out public opinion. They say, you know, justice is blind, so if we look at the litigant on this side and they're wearing a fancy suit, that really doesn't have bearing on the strength and merits of their case. If we look to the litigant on this side and it's a gang member who has tattoos, we need to tune that out because it really doesn't have a bearing on the facts of that particular case. So that's our job at the trial court level. And I think there is a distinction with appellate court decisions.
We are at a time now where accusations have come to equate conviction, and due process seems to not be taken as seriously in the passion of public opinion. Could you share with us your thoughts about the recall effort and the threat to due process?
Sure. Due process is a guarantee. It's enshrined in our Constitution. And we have to be able to give people due process without fear of losing our jobs, without fear of what may come from that decision. Otto Kaus, who was a California Supreme Court justice, spoke famously about what he called the crocodile in the bathtub. And he said something to the effect of when an appellate panel is sitting around the table discussing a case that's high profile, that they all know it's going to make the papers, they all know there's going to be perhaps outrage, disappointment that will be publicly vented. Justice Kaus said, it's like there's a crocodile in your bathtub. You do your best to ignore it, but it's there. And we can't let the crocodile endanger due process. And I would argue that it's no longer a crocodile. It's in the age of social media where information is transmitted so quickly without the vetting that we relied on traditional media to apply in days gone by. The crocodile has become the dragon in the bathtub. And it's our job as judges and justices to ignore the dragon. I think the recall makes it harder to do so.
Judges are afforded, a certain degree of discretion in sentencing decisions. Do you think that judges' discretion should reflect community values, considering judges are appointed by governors and not the community?
A judge's discretion is limited by the statutes, the Constitution, and the rules of court. I've searched those, and I've never seen in any of those documents community values or public opinion. In fact, I've seen the exact opposite in the ethical rules that judges have to follow. Don't let public opinion influence your decision. So the notion that judges should somehow quantify community values, a difficult task in the first place, and then apply those in a court of law to litigants, individual litigants who are seeking fair justice, I think that's wrong. And I don't see a principled justification for doing that. We can't do it ethically. I don't think we should do it. It's up to the legislature to make laws. It's up to the judges to enforce those laws.
two-part questions. We never heard from you. How did you come to the decision of sentencing Rob Turner to 6 months in jail? What do you base that on? And secondly, do you see this recall as a witch hunt?
I'm going to refer the first question to my sentencing transcript, consistent with what I've said before about the ethical rules that apply to pending cases. And I just think the recall is misguided. I just think that you take all that energy and passion that's been put into the recall movement and apply it somewhere constructive. Because applying it to this process, and if you go online and you quantify the dollars spent by both sides, by the county, that's a lot of money. And I just think it's misguided, it's misspent.
Judge, why come forward now, just a few weeks before the actual voting on June the 5th? I mean, it's been, as you said, a couple of years of this. Why not come out and talk publicly sooner?
Because I really think judges should typically zip it and take the heat, take the criticism. It's only when you get to a point where there's a very real chance that the recall will be successful, it gets serious for me. And I think, as I said, it demands a response. And I waited because I really think judges should sit back, take the criticism, but the stakes are too high, I think, now. That's why I've come forward.
Follow up, if the recall is successful and you are pulled off the bench, what do you do?
I live my life.
Do you become an advocate against this kind of thing? Do you do anything beyond just go fishing?
I will do something productive, I promise. I just don't know what at this time. And that's part of that is a family decision. I just have to see what happens.
Judge, you referred to the stakes in your last statement. You said the stakes throughout, but what are the stakes?
The stakes are that judges will feel that, again, that silent, creeping force, that corrupting force of what happens if I decide X. That's not what judges should be thinking about. Judges should be thinking about what are the facts in the case, what are the legal principles that apply, and how do I arrive at a just decision under the facts and the law. They shouldn't be thinking, what happens, who's going to hate me if I decide one way or the other.
Tracy?
Thank you. If you win, Judge, how is it that you could hear criminal cases again, given that some jurors, potential prospective jurors, refused?
I think with time, that issue will go away or resolve itself. So I think it's just the pacifying effects of time on the process, which would allow me to hear criminal cases again.
One question, Your Honor. You mentioned that your opponents have $1 million war chest. What would you say yours is?
It's, I'm going to refer you to because I don't want to give you the wrong information. I don't know the exact dollar figure, but we had a campaign finance statement that was due April 26th, I believe. And it covered the period from January 1 to April 21. And my political committee, I believe, at the end of that process through April 21, had about $83,000 cash on hand. Now, we had spent other money, and again, all of these filings are available publicly online, so you can tell where the money was spent, how much we raised, who we raised it from, if the contributions were $100 or more. So I just invite you to go to that, and you'll get a very clear sense of the money issues in this campaign to the dollars and cents.
Jeff, you've ruled on many cases in your career. Were you surprised at the backlash that happened this time? Were you anticipating it because of who was involved in the sentence that was being given, or was it complete, shock or surprise?
I was surprised at the amount of backlash. And I think that's the world we live in, is the world of social media. And so ideas and arguments and feelings get transmitted at light speed, and that affects the public nationally, internationally. So I was surprised at that. And I'm not a social media person. I'm not on Facebook. I'm not on Twitter by choice and by design. And so I was surprised by that.
Did you anticipate any backlash?
Yes.
Oh, some back, sorry.
In the aftermath of this case, we've seen the laws have changed. The governor signed, I think, in 16. So I'm a little puzzled about why we're here today. And I think a couple people have asked me about your reasoning in the sentencing, and you referred to the statement. I've read that. My impression is that you were following probation department guidelines, and I'm wondering, is it a matter of a discretionary call on your part? I mean, I haven't seen that. Okay, the probation says 6 months, end of story. That you were, you have some leeway, and if he's likely to reoffend, that kind of thing. Is that your impression too? That it's about discretion here?
That what is about discretion?
Well, the reason people are after you is that about the discretion that you was within your duties to you weren't following a set. This is it wasn't like a set sentence that you had to just deliver. You were like, well, consider this, consider that. Am I correct?
Well, I can speak generally, and again, without regard to that particular case, generally, judges have a varying degrees of discretion with respect to any given case. And the discretion afforded judges depends on what the charges are. And it depends on what the penal code says about judges' discretion. So what I can say is that for cases where I have had discretion, I take responsibility for the exercise of my discretion. I take full responsibility for the exercise of my discretion. And I think that that's about all I can say, but I exercise that discretion within the limits given to me by the laws and the rules of court.
You've said the stakes are high, and your supporters are saying that if this recall goes through, that down the road it will affect people of color, defendants of color, and the decisions that judges make. Do you agree with that, and how will it impact people?
I think, and there is some research on this. If you go to the Brennan Center's website, there's some research about the effect that judicial elections have on the relative harshness of sentencing. And the research seems to suggest that as judicial elections approach, that judges' sentences get harsher. And we know that people of color are disproportionately represented in our criminal justice system. So I don't think it's a difficult inference to make that if the research is borne out and the recall is successful and harsher sentences are given, hypothetically, that will disproportionately impact those people that are already in the criminal justice system. That's not a stretch. But again, as I said before, I trust my colleagues in the trial courts of the state of California to do their duty. And I really believe that they will. I just don't think it makes sense to make it harder for them to do so, or to shake the public's confidence in their ability to do so with a recall.
Does anyone not have a chance? Yeah.
Judge, you mentioned how comfortable it is to be on this side of such negative attention. And you talked about it permeating not only your work, but your family as well. How is your family? How has it affected the family?
My family is good. I have 2 boys, age 7 and 9. And in a way, I'm lucky because they're at not the age of teenage scathing criticism. They're at what I call the age of curiosity. And so I've been able to insulate them from the negative impacts of this recall. My son, my 9-year-old son, did, in one of his after-school programs, he came, I picked him up one day and he had seen a pro-recall piece and he just started asking me about it. I just tried to explain it to him in a way that he would understand. And but what I've tried to do is just completely insulate my children from everything about the recall. With respect to my wife, that's been very difficult. And in part because we're in the community and everyone knows about this, and some people feel very strongly and negatively towards me as the result of my decision. And so that puts her in a very difficult position. And it's a position of sort of not knowing where people stand, and not knowing how they feel about you, and not knowing if the way they feel about her husband is going to affect how they treat her kids. So that, it just creates this level of anxiety and uncertainty that we've just had to cope with.
Judge, I know that you said that you're not supposed to factor in how the plaintiffs or the defendants think about a potential ruling before you rule, but I'm wondering, after the Brock Turner case, do you ever think about the victim in that case and how she thinks about how you ruled and how she's doing? Period. Do you think about her?
I do. I think about it all the time. And that's part of the challenge. It's the challenge of limiting yourself as a judge to what you are ethically bound to consider in a case. Another jury instruction that we give to jurors in criminal cases, and I think also in civil cases, it goes along with the do not let public opinion influence your decision. It's do not let sympathy influence your decision. And so judges are people, we're humans, things affect us viscerally, things affect us emotionally. We have a hard job, which is to, again, do that laser focus on the facts and the law, and not to let that creep in the decision-making process.
You mentioned earlier that judicial recall should be reserved for the most heinous of misconduct and incompetence. So what place does judicial elections have, considering that they both serve as effectively choosing who should be on the bench?
Are you talking about a contested election? So for example, in an open seat election, you just have an open seat. Are you talking about when?
Contested judicial election.
Okay, so let's say individual A lawyer challenges individual B, the actual sitting judge.
Yeah, considering
right?
that there are a lot of those
in
San Francisco right now.
That's true. I think it's obviously constitutionally allowed. I just think that the public, as voters, needs to look searchingly at the reasons for, are there good reasons for taking this judge off the bench and inserting this other judge? And it's hard, I think, for voters to get that kind of information in a contested judicial election. And so it does, I mean, the recall is special, but contested elections where sitting judges are challenged raise similar questions of judicial independence. And I just think that we have to be careful about that process. It's sort of, there are things that you can do constitutionally, and the question is, should you do them? People are within their rights to try to recall me. I accept that. Should it be done? People are within their rights to challenge sitting judges. Should it be done? Is there a good reason? And again, I would go back to, there's a record of either incompetence or misconduct. Those would be good reasons to me.
So everyone, I think, has had a chance to answer a question. I'm going to thank you for coming. The one just comment, because this question came up over and over again about will this impact sentences in particular for people of color. The one observation I'd make that you can look at is as a direct result of this recall effort, as someone raised, the law has changed. There's now mandatory minimum sentences with respect to these kinds of offenses. So we already have harsher sentences that will impact people of color disproportionately. They are the individuals who come before the court system disproportionately. So it's not a question of whether judges will be impacted about giving harsher sentences. That may happen, but they will have to now impose these harsher sentences. That is a fact. And that is as a direct result of the recall campaign. So I thank everyone. There's those of us who are here who have worked or investigated the cases that are part of the No Recall campaign. We're happy to stay off the glare of all these cameras and answer some questions you may have that the judge is unable to answer. And those of us who've met Judge Cordell, Elsbeth Farmer, who's here. In the corner is Margaret Russell, a colleague of mine from Santa Clara University Law School for identification purposes only. And myself, Ellen Kreitzberg, also a law professor. So we're happy to respond to some of your questions about specific facts of the cases that you may have that the judge is unable to address. So thank you for coming.
Who donated the $221,000? Who donated that? That was mentioned. You don't know?
Not to our campaign.
Look at the file.
Yeah, not to.
It's here on their disclosure.
Oh, no, that's theirs.
No, I know,
Yeah.
but her name is on there.
Yeah, yeah. You
The
can.
bottom name on the disclosure.
All right. So you've all gotten handouts, I think, that talk about, the last thing I'd say is this no recall campaign. If Professor Russell can come up here, because we've been portrayed as the face of people who are supportive of rape culture. You can oppose the recall and still be individuals, men or women, who are voices for victims, who have been advocates for social justice, who have worked their entire careers for racial justice and fairness in the criminal justice system. And so the initial characterization that we are individuals who support rape culture is flatly false, and that should give you the lens by which you examine the rest of the facts that they're putting out there. So we thank you all for coming. We independently investigated cases because none of us had any specific relationship with this judge before this. It was not a matter of social or any sort of connection. We looked at the facts. We were appalled by what was being presented. We were dismayed at the inaccuracies, the misleading, and the downright lies that were being portrayed. And on our own, we became involved to try and bring the facts. The motto of this campaign is get the facts. So please do that on behalf of the No Recall campaign. We thank you for coming.
One thing to add, that people should know that Judge Persky's spouse is a woman of color. He has biracial children.
All right, thank you all very much. And as I said, we'll stay around to answer your questions about the cases. Why don't I take you?